For the operation of the rule of Resjudicata, number 1 directly and substantially an issue, number 2 between the same parties, number 3 under the same title, number 4 competent court, number 5 finally decided. Number 1 directly and substantially an issue. If it is of the essence of this action that the matter must be directly and substantially an issue between the parties, a matter will be said to be direct and biased and substantially an issue if it was alleged by one party and denied or admitted either expressly or implied by the other. A sues B for rent and defense of A is that no rent is due. There would be a matter directly and substantially an issue. It means that the matter must be collaterally or incidentally in issue. Number 2 between the same parties. It is not necessary under this section that the parties should be common. All that is required under this section is that issue should be between the same parties or between the parties under whom they are or any of them claim. A sues B for rent. B says that M and not A is the owner. Court has held that A has failed to prove his title. A sues B. B says M is the owner, not A is the owner. Court has held that A has failed to prove his title. A sues B and M for declaration of his title. Suit is not barred because parties in both the suits are not the same. To press into service the doctrine of Resjudicata or estoppel by record, it is enough if the party concerned shows that the parties to both the suits were same. Kadapurat Ulam Khalid versus Bhimapura Palam Kakkada Sulekha Yaya 1986 Kerala 251. In the case of Wali Muhammad versus Rahmat B. AIR 1994, Supreme Court 1136 illustrate the situation where parties and property in question is the same. Parties and property in question is the same in the earlier and subsequent suit. Here B in earlier suit filed against A sought declaration of his right to manage and possess a graveyard and dargah. The trial court gave the finding that the property in question was Waqf property and graveyard, dargah and house were under the management of A. The court gave a further finding that the house in question was used as Musafir Khana. It was held that both the above finding operate as Resjudicata and subsequent suit by A as Mutwali against B for possession. Number 3 under the same title. Parties in the subsequent must have been litigating under the same title. This will cover a case where a later litigant occupies by succession the same portion as the former litigant. सेम टाइटल होना चाहिए, एक ही टाइटल के अंतर्गत अगर लिटिगेट करते हैं, सब्सिक्वेंट सूट में भी सेम टाइटल के अंतर्गत अगर ऑपरेट लिटिगेट कर रहे हैं तो फिर क्या रेजिडिकाटा अप्लाई हो जाएगा. पार्टीज इन द सब्सिक्वेंट मस्ट हैव बीन लिटिगेटिंग अंडर द सेम टाइटल. दिस विल कवर अ केस वेयर अ लेटर लिटिगेंट ऑक्यूपाइज बाय सक्सेशन द सेम पोर्शन एज द फॉर्मर लिटिगेंट. The actual test for this doctrine is the identity of title in the two litigation and not the identity of actual property involved in the two suits. टाइटल का आइडेंटिटी है मेन टेस्ट जो है डॉक्ट्रिन का, वो दोनों लिटिगेशन में टाइटल की जो आइडेंटिटी है वो मेन टेस्ट है. एक्चुअल प्रॉपर्टी का आइडेंटिटी इन्वॉल्व वो चीज़ ज़रूरी नहीं है. नॉट द आइडेंटिटी ऑफ द एक्चुअल प्रॉपर्टी इन्वॉल्व इन द टू सूट्स. नंबर 4 कॉम्पिटेंट कोर्ट. बिफोर द इंट्रोडक्शन ऑफ एक्सप्लेनेशन 8 अंडर सेक्शन 11, सेक्शन एक्सप्लेनेशन 8 जो है सेक्शन 11 में डालने से पहले द वर्ड कॉम्पिटेंट टू ट्राई सच सब्सिक्वेंट सूट वे कंसिस्टेंटली इंटरप्रिटेड टू मीन दैट it must refer to the pecuniary jurisdiction of the earlier court to try the subsequent suit at the time when the suit was brought. Mere competency to try suit raised in the subsequent suit was not enough. A decree in a previous suit would not operate as Resjudicata unless the judge by whom it was made had jurisdiction to try and decide not that particular suit but also the subsequent suit itself in which the suit issue is subsequently raised. So the earlier decree of the court of limited jurisdiction would not operate as Resjudicata when the same issue is directly substantial in issue in the later suit filed in a court of unlimited jurisdiction. It was to remove the anomaly that Explanation 8 was appended to Section 11 by the amendment in 1976. The explanation provides that an issue heard and finally decided by a court of limited jurisdiction completely competent to order completely competent to decide such issue shall operate as Resjudicata in a subsequent suit. मतलब कॉम्पिटेंसी भी ज़रूरी है कोर्ट की, ऐसा नहीं है कि इनकम्पिटेंट कोर्ट में डाला है. Notwithstanding that such court of limited jurisdiction was not competent to try such subsequent suit or the suit in which such issue has been subsequently raised, interpretation given in this new explanation by High Court raised an inconsistency in their judgment. Now, this controversy has been resolved by the Supreme Court in its recent pronouncement in Sulochana Amma versus Adner AIR 1994, Supreme Court 152. In the instant case, the court has preferred view of Kerala, Odisha, and Madras High Court, which had given a broader interpretation to the provision. Interpretation given by the Calcutta High Court takes a very narrow view, limiting the scope of the explanation was rejected. The Supreme Court has stated in Section 11 to be read in combination and harmony with Explanation 8 if other conditions of res judicata are fulfilled. The decision on an issue in a formal suit decided by any court, be it either of limited pecuniary jurisdiction or of special jurisdiction like insolvency court, probate court, land acquisition court, rent controller, revenue tribunal, etc. In the words of the Supreme Court, the result that would flow is that an order on an issue which had arisen directly or substantially between the parties or their privies and decided finally by a competent court or tribunal, though of limited jurisdiction, which includes pecuniary jurisdiction, will operate as res judicata in a subsequent suit or proceeding, notwithstanding the fact that such court of limited or special jurisdiction was not a competent court to try the subsequent suit. Principle that res judicata applies to two stages in the same litigation would apply between the stages in the same litigation to this extent that the same court, whether the trial court of a higher court trial or a higher court having at an earlier stage decided a matter in any way, would not allow the parties to re-agitate the matter again at a subsequent stage of the same proceeding, but where an application dismissed has been for non-prosecution without consideration of the merits, it has been held that a second application is not barred by res judicata. Pramod Ranjan versus Nirapada Mandi, AIR 1980, Calcutta 181. Finally decided. The matter must have been finally decided by a court of competent jurisdiction. According to this section, any matter should have been heard and decided finally by a court, and therefore that section does not apply to a consent decree. No doubt it would be open to a court not to decide all the issues which may arise on the pleading before it if it finds that the plaint on the face of it is barred by any law. If the final decision in any matter in issue between the parties based by a court on its decision on more than one point, each of which by itself would be sufficient for the ultimate decision. The decision on each of these points operate as res judicata between the parties. A decision on an abstract question of law, unrelated to fact, which give rise to right, cannot operate as res judicata. Same is true of a mixed question of law and fact. Nor also can a decision on the question of jurisdiction be res judicata in a subsequent suit or proceeding. But if the question of law is related to the fact in issue, an erroneous decision on such a question of law may operate as res judicata between the same parties in a subsequent suit or proceeding. If the cause of action in the same Supreme Court Employees Welfare Association versus Union of India AIR 1990, Supreme Court 24. The best method to decide the question of res judicata is first to determine the case of the parties as put forward in their respective pleading of their previous suits, and then to find out as to what had been decided by judgment which operate as res judicata. Principle of Resjudicata can be illustrated by following example. A plaintiff bases his claim on nearness of kin, but did not mention the family custom, but for which the nearness could not be proved. His suit was dismissed on merits. Then he filed a suit for the relief based on the nearness of kin by family custom. It was held to be barred by res judicata. Constructive res judicata. Explanation 4 of section 11 defines a constructive res judicata, any matter which might or and ought to have been ground of defense or attack in such former suit should be deemed to have been a matter directly and substantially in issue in such suit. Thus, where a plaintiff or a defendant might or ought to have urged a question in a former litigation, he would be stopped from raising the same question in a subsequent suit, either as an attack or as a defense. The other condition res judicata must be satisfied. The matter is directly and substantially an issue constructively if it might and ought to have been made a ground of attack or defense for the determination of the suit. A matter which might or ought to have been made a ground of attack of defense in the former suit, but which has not been alleged as a ground of attack or defense, is by virtue of the explanation 4 to be deemed to have been a matter directly and substantially an issue in such suit. In other words, though it had not been actually an issue directly and substantially, it will be regarded to have been constructively in issue directly and substantially. The exception makes no distinction between the claim or defense that was actually made in a suit and claim or defense that might and ought to have been made. This is known as the principle of constructive res judicata. For instance, a person claiming a relief of possession on the ground that he is an heir of the deceased, cannot in a subsequent suit base his claim on a will executed by the deceased as he to have raised his title on the basis of the will. There should be an end to litigation as a matter of public policy. Then should not be a hardship to an individual by vexing him once again. And there are two principles generating this rule of constructive res judicata. As a defense, if a defendant raised the plea of undue influence for execution of a gift deed, he cannot subsequently raise the plea of fraud or misrepresentation. Distinction between res judicata and estoppel. Thus, an erroneous decision on an issue of law operate as res judicata between the same parties in a subsequent suit, or if so, how far. Res judicata and estoppel. Estoppel is a rule of evidence, and the general rule is enacted in section 115 of the Evidence Act, which lays down that where one person has by his declaration, act, or omission caused or permitted another person to believe a thing to be true and to act upon such belief, neither he or his representative shall be allowed to any suit or proceeding between himself and such person of his representative to deny the truth of that thing, to press into service the doctrine of estoppel by record. It is enough if the party concerned shows that the parties to both the suits were the same. To press into service the doctrine of estoppel by record, it is enough if the party concerned shows that the parties to both the suits were the same. Kadapurt Ilham Khalid versus Bhimapura Sulekh, AIR 1986, Kerala 251. Distinction. Number 1. The doctrine of res judicata results from a decision of the court. Doctrine of res judicata results from a decision of the court, while estoppel results from the act of parties themselves. Number 2. Rule of res judicata proceeds on the ground of public policy, that is, that there should be an end to the litigation, while the rule of estoppel proceeds upon the doctrine of equity, that he who by his conduct has induced another to alter his position to his advantage cannot turn round and take advantage of such alteration of the other's position. Number 3. The rule of res judicata prohibits an inquiry in limine and outs and ousts the jurisdiction of the court to try the case, while an estoppel is only a rule of evidence. Number 4. Lastly, the theory of Resjudicata is to presume conclusively. Resjudicata is to presume conclusively the truth of the former decision, while the rule of estoppel prevents a person from setting up what he calls the truth. An issue of law may not operate as Resjudicata. Two cases may arise. Number A, the cause of action in the subsequent suit may be different from that in the former suit. Or number B, the cause of action in the subsequent suit may be the same as the former suit. A decision on an issue of law operates as res judicata if the cause of action in the subsequent suit is the same as the former suit, even though the decision on the point of law are erroneous. Tarini Charan vs. Kedarnath ILR 56 Calcutta 723. There is a conflict of opinion in the other cases, where the cause of action in the subsequent case is different from that in the former suit. Cause of action is different from that in the former suit. It has been held in some cases that an erroneous decision on the point of law does not operate as res judicata. This is the view of Calcutta, Madras, and Lahore High Court. On the other hand, the view of Allahabad, Bombay, and other High Court is that it does not operate as res judicata. Tarini vs. Kedarnath ILR 56 723. It is the leading case on that point. When can a matter be res judicata between co-defendants? Res judicata between co-defendants. Three conditions are essential when a matter become a res judicata between co-defendants. Number 1, there must be a conflict of interest between co-defendants. There must be a conflict of interest. Number 1, there must be a conflict of interest between co-defendants. Number 2, the decision that conflict must be necessary in order to give the plaintiff an appropriate relief which the plaintiff claimed in the suit. Number 3, there must be final decision of a competent court deciding the conflict between co-defendants. The doctrine of res judicata, however, should be applied with great caution. Number A, the application of res judicata to execute proceedings. The rule of res judicata contained in section 11 of the Civil Procedure Code did not clearly lay down whether it is applicable or not applicable to execution proceedings. The section only says that the principle is applicable to any suit or issue in which the matter is directly and substantially an issue as in former suit between the same parties in a competent court and which have been heard and finally decided by such court. The rule of res judicata contained in section 11 of the Civil Procedure Code did not clearly lay down whether it is applicable or not applicable to execution proceedings. The section only says that the principle is applicable to any suit or issue in which the matter is directly and substantially an issue as in former suit between the same parties in a competent court which has been heard and finally decided by such court. The question of this principle being applicable to execution proceeding has been inserted by explanation 7 and 8 to this section of CPC Amendment Act number 104 of 1976. Thus, it will be seen that the principle of res judicata are also applicable to execution proceedings, which are the outcome of a decree being passed in a suit. Number 1, the decision in the former proceeding must have been between the same parties as in subsequent proceeding. If the parties are different, the rule does not apply. Number 2, the matter in issue in the subsequent proceeding must have been directly and substantially an issue in the former proceeding, either expressly or impliedly, whether the previous decision was only an incidental one or was on a matter different from that in issue in the subsequent proceeding. It would not operate as a bar. Suppose the judgment debtor raises the question of limitation, but the execution application is dismissed for default of the decree holder. A decision on the question of limitation will not operate as res judicata as it was not necessary to be decided. Decision in the former proceeding must have been between the same parties in the subsequent proceeding. If the parties are different, the rule does not apply. The rule of res judicata does not apply. Number 2, the matter in issue in the subsequent proceeding must have been directly and substantially in issue in the former proceeding. The whatever the matter which was raised in the subsequent proceeding, matter and issue, must have been directly and substantially in issue in the former proceeding, either expressly or impliedly. Whether the previous decision was only on incidental one or was on a matter different from that in issue in the subsequent proceeding, would not operate as a bar. Suppose the judgment letter raises the question of limitation, but the execution proceeding is dismissed for default of the decree holder. A decision on the question of limitation will not operate as res judicata, as it was not necessary to be decided. Number 3. When the dismissal for default of objection raised under section 47 of the CPC does not operate as res judicata when the same objection was raised again in the court of execution. Even the dismissal for default of objection raised under section 47 of CPC does not operate as res judicata when the same objection was raised again in the course of execution. Shiva Shankar versus Bakunt AIR 1969 SC 971. Number 4. The litigation is the subsequent proceeding. The litigation in the subsequent proceeding must have been under the same title as in the former proceeding. Thus, a decision against a person in a representative capacity will not operate as res judicata in a subsequent proceeding. Number 5. The court in the former proceeding must have been competent to decide the matter in dispute. The court in the former proceeding must have been competent to decide the matter in dispute. Number 6. The point raised in the subsequent proceeding must have been heard and decided in the former proceeding either expressly or constructively. If an application is dismissed for default of appearance or for non-prosecution as being premature or being too late, the application is struck off for the present and is rejected on preliminary grounds, the merits of the application cannot be said to have been heard and finally decided. The decision therefore cannot be conclusive. The point raised in the subsequent proceeding must have been heard and finally decided in the former proceeding either expressly or conclusively. If an application is dismissed for the default of appearance or for non-prosecution on being premature or being too late, the application is struck off for the present and is rejected on a preliminary grounds. The merits of the application cannot be said to have been heard and finally decided, and the decision therefore cannot be conclusive. The Judicial Committee of the Privy Council have ruled that the principle of Resjudicata applies to such proceedings. The ratio decidendi of Ram Kripal versus Roop Kumari ILR 6 ALI 269 is that if a particular construction has been put on a decree in proceeding on a former application in execution, it is not competent to the court to treat the construction as erroneous and put another construction upon it as subsequent stage of the execution proceeding. In Mangal Prasad versus Girija Kant ILR 6 MAL 551, the Privy Council held that a decision on an application for execution after hearing both the parties, though erroneous, is binding on the parties in subsequent proceeding in execution. Privy Council held decision on application for execution after hearing both the parties, though erroneous, is binding on the parties in a subsequent proceeding in execution. What do you understand by matter? Directly or substantially an issue.